Welcome back to Frontside Press. I'm
Where's
Mike.
the applause noise? There it is.
Oh, there it is. Get him.
What's happening here? Jeez.
Have at it, Jeff.
Oh, you're done? That's your intro?
Well,
Welcome to Frontside Press.
I wanted it to be more professional tonight.
Carrie and you were both rusty after a couple weeks off. Yes, welcome to Frontside Press. Mike and Jeff, every Thursday of the month, 8-ish. We're actually a little closer to 8 tonight because
every
it's
Thursday
a professional show, as you could tell. Every Thursday of the month. Yeah, every Thursday of the week. Yeah, I'm confused. See, I've been off for 2 weeks now, too. So, yes, we have been gone for a couple of weeks now. We had some personal things going on. People were on vacations, and so we had to take a couple of weeks off, but we are back. So thank you, everyone, for tuning in. As always, follow us on Frontside Press on Facebook. That's where we do the live show on every Thursday, and my YouTube website, Musings with MGL. That stands for Minnesota Gun Lawyer, as most of you probably know. But Musings with MGL on YouTube. Please like and subscribe to my channel. I'm still in the low 900s, 907, 910, somewhere around there. So it'd be really cool if I get to 1,000 subscribers. It'll make me feel like a really important person. So please like, subscribe, share, tell all your friends. We are back. Are you doing a toast, Mike, or what? Because Julie's not here. Julie's not joining us tonight. She couldn't make it. So did you find a toast? Hey, special guest stars.
Yeah.
Hi.
Say it from here.
Hello.
Did you get a toast?
Hey, you want to do the toast?
Hello, everyone.
Read this one right here.
Oh, hey, give everybody time to grab their beverage.
All right, everybody get your beverage.
Grab your beverage of choice. Special toast.
Yeah.
May we get what we want, what we need, and never what we deserve.
Nice.
It is if you don't want to get what you deserve.
We like to start every show with a toast. Everybody eventually gets what they deserve, whether it's now or later on.
He's a famous author.
He is.
What's that? I'll show you the book. I'll show you his book tomorrow morning. Go to bed.
Go to bed. Past your bedtime. All right. Welcome to the show, everybody. We have been off for a couple of weeks, but we're coming back with a bang. So we have a special guest with us tonight. We put a bunch of notices out there, so hopefully a lot of people saw that and are tuning in. If not, as always, these will be on the websites afterwards, so you can catch up on them later. But tonight we do have who I like to refer to as the godfather of Florida gun law, John. I'm gonna second that. My shot. John Guttmacher.
The good maker.
Close enough. Guttmacher, Guttmacher. German.
Guttmacher.
Let's hear some applause. There's the applause button. Welcome, John.
Thank you.
Great. Thank you for being here. For many of you already know who he is. If you don't know, I'm going to let him introduce himself a little bit. But the reason why we call him the godfather of gun laws in Florida is he's been explaining on the front of his book. That's why I'm going to read it. Florida and federal laws of firearms, weapons, and self-defense for over 25 years. The man literally wrote the book on Florida firearm laws. It's a book that's been available for years now. You can get it in all types of places. We'll put the link in the description below to where you can go find this book. But if Mike tells this to everybody in his classes, I know that whenever I teach a class, whenever I talk to people, I tell people this. We actually give these books away whenever we do gun law seminars and raffles, because we tell everybody that if you want to know your firearm laws in the state of Florida, buy this book. It is your Bible, basically. It's better than any book I ever read in law school. And then when it comes to firearm laws in the state of Florida, you need to read this book. I have a copy here at the house. I have a copy at my office. And again, we give out copies whenever we do local gun seminars and stuff. So the book is Florida Firearms Law, Use, and Ownership. again, you can get it on the websites below. And so, John, godfather of Florida firearm law, tell everybody about yourself.
Well, there's not a lot to tell. You know, I started started a long time ago. I actually started back in the 70s in Florida, and wound up as a prosecutor, and did that for 5.5 years, which I loved. And then when I got out, you know, I started looking for clients. And when you look for clients, I figured I'll go to gun shows and I'll give out free information on self-defense. And I thought I knew a lot at that time. I'd done quite a few self-defense cases as a prosecutor. And people would ask me questions at all the gun shows, and I would give them my best answer at that time based on about 8.5 years of practice. And then I would say, you know, but come back tomorrow or come back next week or whatever the next gun show was. I'll look it up and I'll let you know what I found. And what I found out was that 50% of the time I was absolutely totally wrong on the answer that I originally gave them. And over a period of years, people would ask me more questions. I would look them all up. And after a couple of years, I became quite an expert on the law, and also discovered that either you know it perfectly or you don't know it at all. There's no in between. And the amount of misinformation back when the book first came out, which was 1993, was incredible. Nobody knew what the hell the laws were, and that included the courts. And my book came out, and it was the first inkling Florida had of what the law really was. It sort of braved the way for knowing what the law is and was. There have been a lot of books and things that have come after me and sort of relied on the book. It's made a big change in Florida and Florida law. It's something that, you know, I love to do. I do 24/7. When I was a prosecutor, I was also a police legal advisor to a narcotic strike force. So I used to go out with them. I was an extra gun and instant legal advice, which was a lot of fun, by the way. And, you know, I've done quite a few things. I'm an NRA certified firearms instructor. I was an FFL very, very briefly. So I've done a couple of things. And I've tried a lot of cases.
Are you
more than your average bear?
Yeah. You're still practicing now, or you retired? This is what you
God
focus on is
forbid.
just writing your
Oh,
book.
no. No, after 40 years of slugging it out. But, you know, I still dream every night about practicing some area of law, from being in a trial or doing discovery or something. It's just amazing. It's every single stinking night. Amazing.
Yeah. That's what happens to me too. There probably isn't a night that goes by that I don't wake up at 2:00 in the morning and go, ah, shit, did I file that discovery response? Did I get that answer in on time? Oh crap, I forgot to look at this dash cam video, or when's the guy's trial date coming up? It happens.
Praying that it would be a
night.
blonde, I used to know, but it never happens.
I know, right? No, right? Well, the good news is my wife is my law partner, so she wakes in the middle of the night and has the same dream. So we tend to both wake up and discuss cases at 2:00 in the morning. It's a little weird.
Well, I'll tell you what. I got a question for the two of you. All right. What do people who do self-defense, all right, who defend themselves, what is the number one thing they do wrong?
Get involved in the first place.
Well, if they have no choice and they can't run, if you can't retreat and you got to fight, what do they do wrong?
Well, you know, there's so many scenarios under your question that there's no way to answer it. I can probably come up with 100 different scenarios of how things can happen. You know, and quite frankly, you know, there's a lot of stuff that's covered in the book as to common scenarios and how you should react to them legally, or, if worse comes to worse and it doesn't go down the way you want, how to react to that and how to handle that stuff. But, there really is no way. I can tell you that from a personal standpoint, as an instructor, other instructors may not agree with me. I like concealed carry because I like to the element of surprise that, hey, I'm the one they don't know is carrying, and that can be.
You're getting an argument for me on that.
Yeah, I agree with that. We're all conceal it, don't reveal it.
When somebody's pointing an AR at me, I don't think I want to draw my gun if I have another choice.
Exactly. Well, I mean, and I would kind of say, right, you're probably going to get the whole lawyer answer of it depends to your question, Mike, because
well, here's why I'm asking.
Back patterns are the most important thing. I would say I agree with his first statement that most of the cases that I get are cases that my client could have completely avoided the situation in the first place. Rarely do I get a case where the person's just walking down the street with their wife after dinner and minding their own business, and some crazy person comes out and attacks them, and they have to shoot them. Most of the time, they've involved themselves in a road rage incident or an alcohol incident at a bar or a domestic dispute with the family member or something along those lines. And instead of extricating themselves from the situation, which is what you guys usually teach.
Yep.
I'm not an instructor. I just stick in the law area, but you guys usually teach, avoid those kind of things. That's the whole point when you conceal carry. So I actually do find that it's usually the people that get involved in it in the first place, and they could have avoided the whole situation.
Well, I just want to add, Mike, let me add that road rage cases, and I handled quite a few, were the absolute worst.
Yeah.
In 99.9999999 of the time, it could have been avoided. It should have been avoided. And when it wasn't avoided, it's the other guy who started all the road rage who all of a sudden is the victim. And they didn't do anything. It's a hard place to be. And I can tell you, I've defended a lot of people. I had a lot of trials. And I had a lot of in-betweens where we wound up with a really good plea that you couldn't turn down. When somebody's offering you a misdemeanor withheld adjudication and you can keep your firearm, I'm taking it. But, a lot of these things went to trial, and they were scary because the person on the other side was usually a really good liar, and it was one person against another. And you don't want to be there. I mean, if you can avoid it, 90% of the time, you want to avoid it. And I'll say one other thing that in light of some of the new law, in light of all the federal laws and all the other things going on, boy, you better believe in the retreat rule today that, people say, stand your ground. We don't have to retreat. And I say, you better retreat if you can, even if you don't have to, because there are so many little niches in the law today where you can get screwed by a prosecutor who says, well, you were breaking federal law, therefore you were in criminal conduct, therefore you didn't have to stand your ground unless you retreated. Well, that's the law today. You better know it.
Right.
People think,
and that's
people think that they're going to be the hero, that people are going to carry them around on their shoulders and stuff like that. And it's like, in the real world, the good guy doesn't always win. You got to understand that.
You have no idea what it's like until you have a client who thinks he's going to skate through this damn thing, and he gets in trial and he is sweating bullets next to you. I've seen people soak their shirt during a trial where they thought they were going to skate through, and the truth hits them. Thank God, they had me, because otherwise they would have been cooked.
Well, and it is weird because it sounds like it hasn't changed much, or it's the same over where you practice. But most of the cases I get, I'd say a good 70% of my cases are road rage cases, and they all have the same scenario. I'm driving down the road doing just fine. Some a-hole cuts me off, breaks me, tailgates me or whatever. I yell some words at him. He yells some things at me. He says something like he's going to kill me. I pulled out my gun just to put it in the ready position in case something happens. I didn't point it at him. I didn't intend to scare him. I just pulled it out, and somehow he must have accidentally seen it. And then the other guy who started the whole thing calls 911 and goes, "This crazy man just pulled a gun on me in the middle of the road." They pull you over. You get arrested for ag assault with a firearm, which is a felony with, prison. And then that's exactly what happens. You get hit with that. You go through some depots. You come up to trial. The state attorney's office comes to you and says, "Look, you can take an improper exhibition of a firearm. We'll give you a withhold and probation, maybe even a diversion program." And then all of a sudden, the person who came in here saying, "I didn't do anything wrong," is begging and pleading to take that deal, because if you lose a trial, you're getting a mandatory felony adjudication. You're probably going to go to either jail or prison on it. But that's how most of those cases, the fact patterns are hilarious. They're almost exactly the same, because nobody intends to point the gun. They try and claim they were scared and stand your ground, but then you're trying to explain why, if you're in your car moving down the road and he's in his car moving down the road, why you were in fear of imminent death or great bodily harm, that you need to show him the gun. Or the clients will always tell me, "Well, I never pulled my gun out." He's lying. But the person could describe that it was a silver gun. It was an automatic. It came from the center console when he pulled it out. And then lo and behold, when the cops pull you over and search your car, they find a silver gun that's a semi-automatic that was in the center console, but somehow they never produced their gun. So it is funny, those road rage incidences are always like a huge master percentage. And you're right, when it comes to firearm stuff, people can talk about how we've gone real pro-gun with stand your ground and all these other things. But I got to tell you, most of the prosecutors, they don't care. They don't like guns. They don't know guns. They don't understand guns. And anytime a gun case hits their desk, they're going to file it, and they're going to come after you no matter what, because that's just the way it is, especially now with all the, mass shootings going on and everything else going on. The state attorney's office, who I keep reminding people are elected officials, care about politics and political stuff like that. And so if you think that you just have the law on your side because that's what the statute says, you got another thing coming.
Yeah, it depends where you live. I mean, up in Brevard, where I used to live, that's very pro-gun, and you're going to get the benefit of the doubt up there. You go to Tampa, or you go to Broward, or you go to Dade, or someplace like that, boy, you got some problems.
Yeah. We have the issue down here, and in our circuit, they're like that. Our elected state attorney is a Republican. He claims that he's in favor of the NRA or whatever, but that office doesn't like guns. They'll prosecute people for gun stuff all the time. It's just kind of weird. Our sheriffs here are all elected Republicans, but yet every single one of them does red flag laws on a regular basis. So if you just think just because there's certain parties or whatever on your side, they're not necessarily going to be there. To the second part of your question, after somebody gets in a legitimately involved shooting, I would say the number one thing they usually do wrong is talk, but that's just the defense attorney in me. I never like people talking to anybody without me being there, running my statement through them. So my instinct is always just to shut up and not say a word. So I find that most of my cases, not even self-defense cases, the problem people get in is they talk, and all you're doing is giving information to the other side.
Yeah, one of the real problems with talking, and I do a modified view of that. I always say, it was self-defense. I was in fear of my life. I had no choice, and I really want to talk to my lawyer before I say anything else. I'd love to talk to you, but I really think I need to talk to my lawyer first. It's important that they know that it's self-defense. It's important that you say it was self-defense. And my experience is that if the police officers are on your side, they may even lead you through that and say, "Hey, it was self-defense, wasn't it?" "Yeah." "You were in fear of your life, weren't you?" "Yeah." If it's anything other than that, if they're looking for facts, they're looking to put you in jail. And the more you talk, the more you're going to complicate it for yourself and your lawyer. Just that simple.
Right. Yeah, there's always those three lines. Like I always tell people to write to give out the standard 3 lines. Or if you have to call 911, if you shoot the person, if you can, you should call 911 and don't give the 911 operator any facts other than the standard. Right? It was in self-defense. I was in fear. I had to shoot the guy. Please send an ambulance. Well, what was he wearing? How far away was he from you? Yeah, you don't need to answer those type of questions because they don't need that stuff to dispatch the ambulance. So there's no reason to answer those type of questions. Same thing with law enforcement. And most cops will understand when you say, I want to talk to a lawyer. If they don't understand that, they've already decided that it's not a self-defense case and you're probably going to go to jail anyway. So you definitely shouldn't talk. If it's clear that it's a self-defense case, most of the times they'll give you the benefit of the doubt and send you home and wait. But what happens a lot down here is I've had numerous cases where law enforcement believes it's self-defense and stand your ground and they don't arrest the person. And then like 2 months later, the state attorney's office decides that it was not a stand your ground and they issue a capias and my client gets arrested at 2:00 in the morning for a case that he was let
If
go
you
on.
want
There's
that.
a lot
I
of
mean,
prosecutors that do that.
if I can, cross-examine a police officer and say, officer, you didn't make an arrest on the scene, did you? And why was that? Well, I didn't think I had probable cause. Well, boy, oh boy, if you don't think
Right.
that's going to have a big impact on the jury, wow. So
Sure.
I'll pray for a case like that.
Yeah, I get them all the time down here. All the time. It's crazy. All right, Mike, you got any other or questions that you want to ask us?
Yeah, I mean, like, what happened is I was reading an article last week, and it was where the question came from is, like, I would think that the number one thing people do wrong is they try to plead their case to the cop. Because I always teach, like, here's the deal. He's not a judge. He doesn't get to decide if you're, guilty or innocent. So don't. I mean, that's why they give you the Miranda rights. You got to understand that the Miranda rights are the shut the hell up law. They had to make a law because people said too many stupid things. So they're just like, just shut the hell up. There's a reason for that. If the situation was the other way and it was you and showing up on a scene where a cop had shot somebody, he wouldn't tell you anything because he knows exactly how the game's supposed to be played. He knows he's better off if he doesn't tell you anything. People don't understand that they're incriminating themselves when they talk. The other thing is they were saying that a lot of people draw their gun in self-defense. The guy decides he has chosen the wrong victim. He runs away, and then they run away, and they don't call the police. So there's the two things I, just wanted to bring up and see what you guys had to think about. What you thought about those.
What I thought about what?
Like, do you deal with? Did you guys deal, or do you deal with whatever a bunch of cases where? Like people leave the
People
scene.
try to talk themselves out of their situation.
Figure out what you're going to say.
Try to talk themselves out of it.
Right. Yeah, that's what people usually try and do. I think, like I said, John's advice and again, what everybody else gives is basically the same. You get out the self-defense facts and call it a day, because that's what usually happens is people think that they can talk themselves out of it. They can explain a narrative, and they might not, usually they're not lying on purpose, obviously, but when something like that happens, it happens so fast, your adrenaline's pumping, your mind's not racing, and you say something as simple as, well, yeah, the guy was, about 2 or 3 feet away from me, and then they measure it, and he was actually like 6 feet away, and then all of a sudden the cops go, oh, you're lying, and you're being inconsistent with your story. So,
or if you leave anything out and you
right.
Add it later, they'll say that was made up.
Right.
So anything that's inaccurate, anything that's left out, there are just too many things you can get yourself in trouble with about talking. However, if you're defending yourself inside a home or inside a business, it becomes a very different procedure, because you want to show them where they broke in. You want to show them where the window was smashed. If you're injured, you definitely want to show them where you're injured. You definitely want to have them take pictures. You definitely want more than one police officer to see that or hear that, because I've had plenty of cases where my client told one police officer, and that guy, he's the one who doesn't show up at trial, and nobody else knows what the hell you said that would have helped your case. So there are a lot of things to remember. One of the things to remember is if you're defending your home or your business, well, at least your home, you have the presumptions that are protecting you in Florida. You're presumed to be in fear of your life. So why the hell would you start, talking about everything that happened? Because it can only get you in more trouble. You may undo the presumptions. So if you're in a defense case from your home, you're in really solid ground in most cases in Florida. It's only when you step out that front door that you get in trouble.
Right. Well, and I find that a lot of people, and as you just pointed out, there's a presumption that if you're in your home that you're going to be in imminent fear. There's a presumption that the person is there to commit a crime. But like all presumptions, they're rebuttable. So yeah, if you give them any evidence that basically says, "Wait a minute, you
They're not
couldn't have been,"
rebuttable under Florida law.
They are or not? I'm sorry, my dog's
They're
barking.
not rebuttable under Florida law.
Oh,
There's plenty of
okay.
case law.
So if a shooting happens in your home at night, you get a presumption that you were in fear, and the prosecutor can't prove that you weren't in fear?
You're in my friggin' house at night.
You can't prove it. There's case law. And there's been case law for years and years. It's nothing new.
So then when the person comes to the seminars, the gun shows, and says, as long as a person's in my house, I can shoot them, even if it's a 14-year-old with no firearms and is making no threats to me, you can't be prosecuted for that?
Theoretically, no.
You're always going to go to court.
Theoretically, no. But you push the limit, and somebody will find a way around it. There are constitutional issues that nobody's raised so far that I'm well aware of, that I would be scared to see a prosecutor raise because they just might win.
Right.
My book isn't a guide to prosecution. It's a guide to defense and people who might get in trouble or want to stay out of trouble or whatever. But as a prosecutor, I could be a real mean son of a bitch.
Yeah, that's funny. So many people. I went through the same path when I got out of law school. I started at the state attorney's office, worked there for like 6 years, and then went into private practice, and then started doing gun trusts and then going to shows and stuff. So most of us are prior prosecutors, so we kind of get to see things from both sides of the table.
Let me ask you
I've been
this.
doing this a lot longer than you have. Like I say, I started back in the 90s. Well, actually, I started back in the 80s here in Florida, but the book came out in the 90s, and I've seen the law change. Let's see, 1978. I was practicing in 78, so I saw when the stand your ground law and all the new self-defense laws came in. I've seen a lot of stuff, so I've got a longer history of reading all those cases and dealing with all those cases than most people, which doesn't hurt, my insight.
So you were practicing back when Florida followed the 3-step rule, then, huh?
There was never a 3-step rule. There was people
Thank you.
Right.
Couldn't learn what
That's the
the
joke.
statute said, and so interpreted it in a way that they might be able to understand it, but they weren't correct.
Right. That's a constant joke that we have, because we still to this day get people. I always tell this story. I was in a local gun shop, a real popular one here local. It's probably the oldest gun shop that we have, and I'm in there shopping one day, and the guy behind the counter is selling a dude a gun, and he's like, "Oh, can I carry this into my car?" And I shit you not, the guy says, "Well, Florida follows the 3-step rule when it comes to carrying in your car," and this was like 2 years ago. And so I just had to walk out before I caused an incident in there. So to this day, that myth still pervades experts allegedly who are working at gun shops behind the counter. So it's a myth that will not die.
If they haven't read my book, they don't know the law. It's that simple.
John, I can honestly tell you, like, I can't tell you how many times I have gone to your book, right, and to look up answers to questions that people have asked me and to go and prove to them the answer to their question. All the time digging in that book, but
I still do it. I mean, yeah, I've been doing firearm law now for, I don't know, 10 or 12 years. I certainly don't know everything. I had to ask John a question like yesterday or the day before because a topic that had come up that I'd never seen before basically popped up. So even when you think you know everything, I mean, maybe John knows everything, but they usually teach us as lawyers, right, that you just can't know everything, and it's okay to give an I don't know answer, and I'll get back to you tomorrow. I mean, now when I go to gun shows, I tell people to email me the question. You couldn't do that in 70s, obviously. Yeah. You had to tell them come back the next day. So now it's as simple as you just give them a card and tell them to email you, or pay me
I'll send you a letter,
hourly retainer, and I'll be happy to research it for you. So
yeah, you need thinking time. You can't just answer a question off the cuff in a firearms case, because when you think about it, you may say, "Oops, I would have given the wrong answer." There's so many nuances that are involved in firearms and weapons issues, even in the non-self-defense areas with what's an antique firearm and stuff. It's amazing how much people don't know. I remember I once had a case with a Webley, and people were saying, "What the hell is a Webley?" I walked into the courtroom and I basically told them whatever I wanted I could get, because they didn't know what the hell I was talking about. Webley, what is a Webley?
Yeah. Well, and the funny thing is you talked about how back then people didn't seem to know the law and stuff, and so that's how you had to write it. But I still find to this day that most people who practice law, even criminal law, don't know the gun laws. There aren't really any other defense attorneys locally where I practice. All the defense attorneys call me when they have questions, or they email me when they have gun questions. I can tell you none of the prosecutors know firearms law. They don't know terminology. They don't know how to work. They don't know how they work. Most of our judges around here, there's bar rules. You're not allowed to bash judges. So our judges are the best judges that exist in the state of Florida, but even they sometimes don't know all the stuff about firearm laws and stuff. So sometimes they'll call me. I've been invited on panels by judges that when they talk about red flag laws and stuff, because they know I'm the only person who kind of knows about it. So even though this book's been out there all these years, it's still kind of scary in the legal field. Just the sheer lack of education and knowledge that they have. And a lot of the lawyers around here are kind of, not to be political, but most of them are Democratic or left leaning. And I had one the other day email me and ask if I could take a case from him for a client that wanted to get he was arrested. They took his guns, and now they're giving him grief about getting his guns back. And he asked me to do it because he said he just can't be part of a motion that would give guns back in the hands of private citizens. And so he referred the case to me. Right. Fine. I'm happy to take the case and the guy's fee, but that's kind of what you deal with a lot of attorneys out there. Not only do they don't know about it, they don't want to know about it.
All right. So I got a question for you guys.
It's a complicated area. It's a very wide area,
All right.
One of the things you mentioned, which is going to be very important starting July 1st, is this new law that allows anybody who could get a concealed weapons license to carry concealed even without the license. And a concealed weapons licensee has to, pardon me, has to take a course. They get at least some minimal training. And these people who are going to be able to carry concealed have zero training. I don't understand how they could have passed such a law. Amazingly.
I'm just saying. All right. I got a question from one of the viewers, all right? So Cody, here's what he said. He was given back a firearm that was stolen from him 10 years ago, just recently. It was found at a crime scene and sat in the Charleston PD for 3 years. Well, I can't get it back up. But he wants to know if he ever gets pulled over and something happens, is he could be tied to that crime because of this.
No. It's very simple. No.
There you go, Cody. From The Godfather. That's it.
Somebody's thinking too hard over there. I see a possible
I
other
like it,
answer.
Cody. I like it because we get questioned.
Yeah. Well, and I find that out. What I find there are two types of people who ask me questions. There are people who underthink it, like, oh, I can just do this because I know that's what the law says. And you're like, actually, that's not what the law says. And then the people who overthink it, who think that like every little thing is going to come out to get them and everything they do with their firearm is going to get them in trouble. And people are spying on them or whatever. I don't get a lot of people in the middle. I get the people on the ends of the perspective. Then of course you get the Facebook ones that think they know everything and they're answering questions on the forums and they're answering them wrong. And then you try and tell them that they're wrong and they're like, no, I'm not. And you're like, okay. So I'll reiterate again, people, don't get your gun answers from Facebook. Get them from the book, get them from the Florida Firearms book. Or if you can read English, usually you can get them from the statute.
Skinny's on.
Oh, awesome.
Just to make sure you all know, this is the cover of the latest edition.
Yeah,
and
mine's
there's
the old
newer one coming out in about another week. That's even later than this one.
Get the book. Get the book.
Is your newest one going to have the stuff with the new law, or are you saving that for the next supplemental when it passes after July?
No, if there's everything, the book was completely redone for this new law. And there were also 3 changes in federal law. So that was also important. And there's also been some case law, like I alluded to earlier, in Florida on the retreat rule, where I think that we need to take a new deep look at the retreat rule and recognize that it exists all over again. I thought we got rid of it, and we did when the original Stand Your Ground came in, and then they decided that they needed to screw that up, and they did about 10 years later. They did a good job screwing it up, too.
Yeah, there's definitely there's a lot of prosecutors out there who want to push the envelope and don't like the current laws, so they want to try and make new laws. I got in a fight with one up in Pinellas County a month or so ago about a rifle in your car and everything else like that. And everybody's like, she's wrong, but they're like, I don't care. I'll file a motion and we'll see what the judge says. So I had case law and everything that said they were wrong, and they just don't care. They think they can make new law or whatever. So if you think something is black and white, it's not.
Well, it's not the Florida that, I moved to a long time ago. We now have half in New Jersey and half in New York up in here. So they brought their politics down, and they brought their no guns down. And until you start seeing it, people used to drive around with guns in the back, and it's no big deal. It's changed big time.
Things haven't changed.
Yeah.
Idiots have gotten more popular.
Yeah. Well, the other problem I always run into is I can't get a clean case, and I'm sure you experienced this, John. Like I can't get the squeaky clean person who's driving down the car carrying their gun correctly and just gets an overzealous cop or a prosecutor. They might be carrying their gun correctly, but they also have a suspended license and a bag of marijuana in the trunk and a passenger who smells like marijuana, so it tips off the dog. Like I can't just get clean cases. And then when you're like, oh, this is great, I'm going to file a motion, I'm going to get a ruling from the judge to throw out charge number 3, And yet the prosecutor's like, okay, if you do that, that's fine, but I'm doubling my offer on charge number 1 and 2. And you're like, well, God damn it. Now I can't have your thing. So it's impossible to get a clean client.
I used to get all the clean ones, let me tell you. And then I'd turn around after the case was over and I'd sue the police department. So I'd make my smaller fee off the criminal case, and then I'd make my good fee off the civil rights case.
Nice.
I did that all the time. It was the only way I could stay in practice.
Yeah. I've done a few of those false arrest cases, but they're pretty good around here. Like I said, it's usually something that
they're tough cases. Nobody wants to touch a false arrest case because the government would rather fight you to the end than pay you a dime, usually.
Right. You have to give them your letter and then wait the 6 months and then fight with them over it. Meanwhile,
just beat them to death in trial.
Right.
So let me ask you this, John. What are you doing for EDC? If you don't mind talking about it.
What is EDC?
Carry. What's your everyday carry?
EDC, everyday carry.
What's my everyday carry? God, my God. All you got to do is look on the cover of my book. I've been carrying.
Well, that's why I'm
asking. I love Kel-Tec. What can I say? It's not an expensive gun, but boy, it shoots where I point it. It's lighter than hell, so I can carry it no matter what I'm wearing. It's reliable. I've never had a misfeed or a misfire with a Kel-Tec. There are a lot of more expensive guns out there. And there are a lot of guns I'd rather carry because, quite frankly, I'd rather carry a 1911. But just the weight and all, I'm not going to carry it. So what can I say? If they pass open carry, I may change things, but I'd probably still conceal. You carry what you can carry.
Did you used to carry the car?
Sorry?
Did you used to carry a car, PM9 or whatever? Wasn't that one of the guns that was on the covers way back in the day?
Anything you saw on the cover, I've carried at some point.
Right.
But a car. You're
way
talking
back in the
about,
day,
you're talking about a short barrel AR. Aren't you talking about a short barrel AR with a car? I mean, I've shot cars. I don't
No. No, the KAHR PM9. I thought that was on the cover of your.
I hated that gun. Good.
Yeah, me too.
It was free,
Yeah, that happens. Well, I'm just glad you answered the question. The answer we usually get is, I don't carry anything. All my guns sank in a boat accident. So
yeah,
at least you were man enough to answer the question. Here in the Gulf Coast of Florida, we get a lot of boating accidents.
Talking about cars, I used to love to shoot a car. That was just a wonderful rifle. One of my favorites. Although I'll take a Kaliningrad. I even can't pronounce the damn Russian name, but you know what I'm talking about.
Kalashnikov.
Kalashnikovs, yeah.
They're fun.
What? While we're on the topics of SBRs, what's your thoughts on this whole brace situation?
Well, if you really want to be honest with yourself, how the hell did they ever pass a brace as not an SBR? Okay, that's really your answer. ATF let them get away with it, and it keep on getting more and more and more and more until finally ATF said, "Oh my God, we got to do something." These were always SBRs, at least the way ATF originally defined them. You have to remember that ATF defines stuff. It's ATF land or Alice in Wonderland, and whatever they say it is, it is. Whatever they say it isn't, they didn't say that. You got to figure that out on your own. It's real Alice in Wonderland stuff. And even as an attorney, NFA is quite a challenge. Quite a challenge.
Yeah, I mean, I was always of the situation too that it was a workaround for the stock situation. I mean, clearly people were using it that way, especially when the later models came out, were telescoping and everything else like that. But right, I think the issue is the ATF got themselves in a pickle by continuing to issue letter after letter saying it was okay, and then just one day
Exactly.
reversing themselves and saying no, it's not, after 30 million of them or whatever the estimate is has been sold, and then you retroactively make people felons despite the recapture window or whatever. It's just, I think that's what rubbed people the wrong way. If they'd have just come out in the beginning and stuck with their original, like you said, there was a yeah.
To do
Yeah, I
it.
know you're running out of time
I
now.
agree. Yeah, I think that, I'm sure Second Amendment Foundation or somebody like them has already taken that up to court somewhere, and I would be surprised if the court didn't say that ATF doesn't have the right to do what they did. But in the meantime, you don't want to be a
Right.
felon, do you?
Right. It's like everything else. Well, that's what I keep telling people is there's already something like 47 something lawsuits out there, but unless they can find a judge who's going to issue an injunction and pause the law from taking in effect on May 31st or whatever it is, then you're going to have to comply. Maybe like the bump stock ban, after 2 or 3 years, it gets overturned. But in the meantime, you can't do it. So it's like one of those things. And I do agree that I think they're going to start reining in the ATF here if some of these cases start getting up to the Supreme Court. They already did it with the, what was it, Mike? The lowers, like the 80% lower
80% lowers. That can't do that.
Right. And then they actually issued an injunction in that case and stopped that from taking effect while it's going through, but nobody's issued an injunction in the brace situation yet.
Well, I mean, they overruled the bump stock.
Right. They just now overruled that, though. There was never an injunction in that case. It took 2 years.
Except Florida has its own statute on bump stocks,
Right.
which survives that problem. The
right.
ruling.
Yeah, that was a federal ruling. That's whatever. Yeah,
that was a federal ruling. Florida still has bump stocks and all sorts of triggers fall into that too. A lot of aftermarket triggers fall into the bump stocks under Florida law.
Right. It's I get a lot of questions about that case all the time too. Are binary triggers legal, and the no reset triggers, because everybody's like, it's supposed to be a bump stock, but when you read it, it's a very vague statute that encompasses anything that can make the gun fire faster than standard firing, I guess. And so I've just been advising people.
Here's my
you may have a different opinion, but I've been advising people that those binary triggers and stuff are probably going to be a problem if you ever get caught with one.
Well, if they arrest you for it, that would be.
Of course, right.
I mean,
this is the issue.
Feds don't really care unless it's. Well, I take that back. The feds do care.
Right. Well, this is what I always tell people is like, they're not driving around kicking in doors looking for people who might be violating the NFA or might have a binary trigger when they're not supposed to. The problem is when you do have to use it in a self-defense shooting, and then they look at it and they're like, well, you're not supposed to have this, or it's the whole medical marijuana card thing. Or
usually when somebody
have both. And go ahead.
Big thing where people got caught on problems with having full autos and other NFA things was, you get in trouble with the wife and you have a domestic violence thing, and the police wind up at your home and they're seizing all your weapons, and surprise, this weapon and that weapon are NFA. Now you're in deep, you know what.
Yep.
That's how it always happened in the cases that I handle.
Right. That's what I always tell people too. And they're always like, oh, concealed means concealed. I'm like, yeah, you say that until something happens and you have to use it, or somebody finds it. And it could be something like you're saying that you're not even involved in. You could be in a car accident and you get knocked out in the car accident, and they take you out, and they're at the hospital taking your stuff out, and all of a sudden a suppressor comes out of your jacket that's unregistered, and you didn't have anything to do with it, but all of a sudden now people are looking at it and saying, hey, what the hell is going on here? So lots of times it's you may not even be looking for it. It just happens to find you. So that's what I always tell people. I'll ask you this question because it's another joke that we always talk about, because people ask about it all the time. What is your take on medical marijuana and firearms? Can you have both cards? Can you not have both cards? Can you smoke medical marijuana
Well,
and still possess a firearm?
You know I've been
Well,
drinking. Why would you do this?
look, if you're smoking, then you're a prohibited person. It's that, simple. Uh, However, having the card technically does not mean that you are smoking. It means that you have a card that you can get medical marijuana if you want. But the card could be used as evidence if somebody was prosecuting you. So the danger isn't that the card is going to stop you from getting a concealed weapons license, or that the card is going to get you arrested, because it's not. But if somehow you are arrested, the card can be used as evidence showing that you're using or likely using marijuana. They would need some other evidence besides that, of course. But I wouldn't want to have somebody saying, I saw him smoking marijuana and here's the joint that he used. And by the way, we have a card that shows that he has a medical marijuana card. Well, son, you're a prohibited person then, and we can prove it. But
Right.
just having the card doesn't make it.
Right. I think the confusing part of that is, right, you could have the card and not be a user. Where I always think the possible issue may come in is that the law tells an FFL dealer that if an FFL dealer knows the person buying the gun has a medical marijuana card, that the FFL dealer then has a reasonable belief that the person uses marijuana, and they're supposed to deny the sale. So I think there is kind of in the statute a presumption on FFL dealers that the person is using. There's no case law or anything that indicates that presumption goes to not the FFL dealer, but the person. So I think the FFL dealer could technically be charged if they sold to somebody who they knew had a card under that statute. But could the person who just wanders down the street and has a concealed carry firearm, but also has a card but isn't smoking, would the presumption go on to them? I think it's another one of those areas where, since there isn't really any case law right now, do you really want to be the test case for the person who gets some overzealous prosecutor or judge or something who wants to make you the test case? I mean, that's up to people to decide on their own, I guess.
But you're right. I mean, ATF about 2 years ago in one of their newsletters made it quite clear that if an FFL sold when they were aware that the person had a marijuana card, that FFL was in trouble.
Right. So that if the presumption is on the FFL, I could certainly see a judge or somebody extending that presumption to.
No presumption. They said don't do it.
Well, right.
Period.
Well, because I think the reason they say don't do it is because they're presuming that if the person has a card that they're illegally using the substance. So could they take that presumption that they put on the FFL dealer and put it onto the person? And what's the point of getting the card if you're not gonna use? Like, I don't understand why even create the gray area on that. And it's a weird little scenario with the concealed carry, with the new law that's coming out, because right now, if you have your concealed carry permit, and let's say you're bebopping down the street smoking marijuana, and a cop sees you, they can't arrest you for that, basically, if you're not impaired. But if you're just holding a blunt or whatever, there's no criminal charge there. What they would do is basically notify the ATF or the FDLE and have your license suspended for doing both. They'll arrest you for the marijuana on misdemeanor, but there's no firearm charge. But under the new law, in order to carry without a permit, you have to be eligible to have a permit. Well, if you're a user of marijuana, you're not eligible to have a permit, which means you can't carry without one. So now that same guy is going to get a third-degree felony carrying concealed firearm charge for walking down the street with a blunt in his hand, where the guy with the card isn't.
You can get a concealed weapons license even with the card today.
Right. What I'm saying is a lot of times people now won't get won't. I'm not talking about the medical marijuana card. I'm talking about if you just have a concealed carry permit and you have your gun, and let's say you're holding a bag of marijuana, there's a marijuana charge there, but there's really no firearm charge. And trust me, I've had clients in this situation, so there's no firearm charge. But now, if you decide to carry without a permit, you're just going under the new law after July 1st. You wouldn't be eligible to get a permit because you're using the marijuana. So now you get the concealed carry firearm charge. Whereas if you had the permit, all you'd get is a letter of suspension from the state. So it's this new law is going to confuse a lot of people.
Can you imagine the problems police officers are going to be going through with this new crazy law?
Well, that's their issue. I mean, the other thing is I currently still have cases in my caseload of people who got arrested now for carrying concealed firearm who in the same set of facts on July 1st wouldn't be a crime. So imagine how fair that is. I mean, to me, I think if you're a prosecutor, I understand the law is the law, but out of morality, you should maybe say, look, the legislator's spoken here. I'm going to go through these cases and maybe get rid of some of them. But I've still got people now who are facing those charges where if they'd waited 2 months, and then there were so many people when he announced that they were signing it that thought the law went into effect that day and didn't realize it waited until July 1st. And now all of a sudden these people just started carrying without a permit for the next 3 months because they thought it was it was in effect that day and didn't realize that it has to wait until July 1st. So very
more business for you.
Hey. Problem is it's going to be less business, unfortunately, I think, for people like Mike who teach the classes and stuff, because I think, unfortunately, a lot of people aren't going to take the class. Are you still being busy? I hope so. I'm still telling everybody to take the class and get a permit because you still get some reciprocity stuff. You can still skip the waiting period for having to get your firearm. So to me, there's lots of reasons to still get a permit. So I'm still telling everybody to do it. But
school zones.
Here's what
federal school zone law that if you have the concealed weapons license, you don't have to worry about. You have the issue with going on school church grounds that has a school that with a concealed weapons license you don't have to worry about. You have even hospital parking with a concealed weapons license that you take that out of the problem zone. There's so many things that that concealed weapons license is still important for.
We have started to do this. We've taken our initial like gunfighter class, and we've added law to it, and we make it so that it's legal to get your concealed weapons license. So we're running 6.5-hour classes, and we're at the point right now. We ran one; it filled up so fast. We had to book another one immediately. That one is filled up. Now we got to book another one, and we're not even into June yet. You know, it's like as far as business goes, there's a lot of people out there that are just like, hey, I'm getting a gun. I still want my license because I don't want to carry without a license, and I need to know what's going on, and I need training, and they're calling me. Like I'm getting like 1 to 3 calls a day about this. So there's a lot of people out there doing the right thing. So I want you guys to understand that.
Go sell some of my books, will you? I know you recommend them.
I
pimped your book got them right there.
For the last 18 years, John. Like I'm pimping that book every class. Jeff is too. But well, nope, can't hear you. Yep. So we're gonna wrap this up anyways. I heard the chimes in the background, so I know we're after 9 o'clock.
We are.
John, don't hang up after. I want to talk to you about a couple things if you got a second and you don't mind.
Sure.
I want to ask you about some things that we got going on. You got Skinny messaging in saying that he sold so many of your books for the 15 years that he was in Florida when he was doing classes out of Young Guns, right? So I just want to let you know. So That ain't working. So I'm going to wrap up. John, I can't thank you enough for being on the show. Hopefully this is just like the beginning and the first time, and we can get you to, get on the show as much as possible as we can get you on here, because it's an honor for the both of us. I can talk with Jeff. Well, I'm talking with Jeff because you don't have a mic. But anyways, I can't tell you how much it means to me to have you on the show.
Thank you.
So
I appreciate that.
But we're going to wrap it up since his tech ain't working anyways. So check us out next week, next Thursday. I'd say at 8-ish, but it may be 7-ish depending on what Kerry says, because we may be live at a Jeff said no. Okay. So we'll talk about that during the week. We'll let you guys know what's going on in the week. Once again, check out John. If you don't know who John is, go check him out. Buy his book. If you don't have at least one of his books, you need to go buy out the new book.
There you are.
Son of a bitch.
All right, Jeff, take us out.
Yeah, you said it all. Go to his link. I won't put this up because it's the wrong cover photo. Go to the link. Get the newest version of that. I can't stress that enough. Please go get the newest version of that. We are doing so I was going to say, Cynthia is another gun lawyer in town. This Saturday from 10 to 12, we're doing a Ask the Gun Lawyer seminar at the Gun Shop A in downtown Sarasota. It's free. We're going to have some donuts, some coffee. We're going to have some of these books to give out. We always raffle these out at the thing, and it's your chance to talk to a couple lawyers and ask us some questions that hopefully we know the answer to, and if we don't, we'll get back to you later on. So anybody who's local, we'll see you at the Gun Shop A on Saturday. Yes, John, thank you very much for being here. That would be great if we can have you back more often. That would be fantastic. There's going to be a lot of new laws, I think, coming out, new cases. We got some new judges, new Supreme Courts. I think it's going to be constantly changing here in the future. And of course, it's election season. So whenever it's election season, you tend to get more shootings for some reason, and then you tend to get more politics when it comes to Second Amendment. So there'll certainly be a lot to talk about here in the future. So Frontside Press every Thursday around 8-ish. Musings with MGL. Please like, subscribe, share our channels, and we'll see you all next week.
1,000. Play music.
Bye.
Thank you.